Excellencies, distinguished members of the committee, and fellow panelists, I want to thank you for having me here to speak on behalf of the Hind Rajab Foundation. I suspect that many in the room will already be familiar with our work, but for those not aware of the HRF, allow me to make a brief introduction. The Hind Rajab Foundation was established in 2024 by several volunteer lawyers and activists determined to use both national and international justice systems to hold Israeli soldiers to account for their war crimes, crimes against humanity, and genocide in Palestine, particularly in the Gaza Strip. The foundation was named in honor of the memory of Hind Rajab and all victims in the Gaza genocide. On the 29th of January 2024, Israeli soldiers murdered 6-year-old Hind, along with several members of her family, as they attempted to flee Israel's onslaught in northern Gaza. The IDF attacked Hind and her family as they attempted to drive to safety, killing everyone inside the vehicle except for Hind and her cousin, Leon Hamadeh. Leon was killed by Israeli gunfire as she spoke with the Palestinian Red Crescent Society over the phone, leaving Hind alone in the car to beg for rescue. Hind hid in the car for hours as she awaited help, but when the ambulance arrived, it too came under Israeli fire. After roughly 2 weeks, Palestinians were finally allowed back to the scene of the crime. There they found Hind's body, the bodies of her family, the bodies of the medical workers, a destroyed ambulance, and the car in which Hind was murdered, riddled with at least 335 bullet holes. I wanted to begin with the story of Hind's murder because it is, in many ways, illustrative of the genocide as a whole, as well as of the reasoning behind the HRF's work. Hind was murdered in plain sight. The world heard her last words and saw the carnage. The genocide in Gaza has not been a secret. The perpetrators have not sought to hide their work. The genocide has, rather, occurred in the open, live-streamed for the world to see. Not only has it been live-streamed by Palestinians documenting what are, in many cases, their final days, but it has also been recorded, unashamedly, gleefully even, by Israeli soldiers themselves. Despite the overwhelming body of evidence of criminal actions by the IDF, documented by both perpetrators and the victims, not one soldier and not one official has yet been held to account in either a national or international court. The closest the world has come to criminal accountability for Israeli crimes in Gaza have been the warrants issued by the International Criminal Court against Benjamin Netanyahu and Yoav Gallant. But while both Netanyahu and Gallant do bear responsibility for the atrocities in Gaza, these atrocities are committed directly by soldiers on the ground, by the pilots flying the bombing raids. Netanyahu did not shoot Hind Rajab to death. Individual soldiers did that. This genocide, like others before it, requires a vast logistical and operational apparatus, and this involves perpetrators from the highest-ranking officials down to the lowest-ranking soldiers. While the ICC focuses its limited resources on the highest-level perpetrators, the vast majority of perpetrators and insiders, particularly the rank-and-file soldiers, continue to escape any modicum of accountability. The Hind Rajab Foundation is committed to breaking this cycle of impunity by identifying and pursuing Israeli and dual-national individuals responsible for committing or facilitating these crimes, wherever they live or travel, by initiating offensive litigation in domestic and international courts. Our strategy has 3 tiers. First, we file requests for prosecution in national courts against what we call traveling soldiers. These are IDF soldiers traveling abroad, often between tours in Gaza. Our team of researchers is constantly building dossiers of evidence against these soldiers, and whenever we become aware of their presence in a foreign country, we move quickly to present this evidence as well as a prima facie legal case to the relevant prosecuting authorities. The most pressing challenge on this front is establishing jurisdiction. In a number of instances, states have expressed a reluctance to apply universal jurisdiction over traveling soldiers, but their domestic and international legal obligations demand otherwise. The majority of states have in some way incorporated the principle of universal jurisdiction over war crimes, crimes against humanity, or genocide, or some combination thereof, into their own criminal codes. In these states, jurisdiction can be established by the mere physical presence of a perpetrator on their territory. It is our view that these cases, which involve both grave breaches of the Geneva Conventions and violations of the Genocide Convention, are the paradigmatic use cases for the exercise of universal jurisdiction. Indeed, states have an affirmative legal obligation to exercise such jurisdiction. According to Article 146 of the Fourth Geneva Convention, and I quote, "Each high contracting party shall be under the obligation to search for persons alleged to have commit or to have ordered to be committed grave breaches and shall bring such persons, regardless of their nationality, before its own courts." As the ICRC's 1958 commentary to the article further underscores, as soon as a contracting party realizes that there is on its territory a person who has committed such a breach, its duty is to ensure that the person concerned is arrested and prosecuted with all speed. Crucially, however, jurisdiction here is contingent upon quick action by the prosecuting authorities, which must launch an investigation and initiate criminal proceedings before the perpetrator has a chance to flee and thereby escape accountability. This is not merely a hypothetical scenario. Already numerous Israeli soldiers have fled states or been evacuated by the Israeli government in response to filings by the HRF. In Brazil, for example, a vacationing soldier fled the country with the help of the Israeli government after a judge ordered federal police to pursue an investigation into that soldier's war crimes in Gaza. Public communication sometimes, then, becomes an important part of the strategy, as it can be necessary to quickly generate political pressure and public demand for prosecution in order to secure jurisdiction and to help prevent escape. Likewise, states must act quickly to detain or restrict the travel of any soldiers placed under investigation. The second tier involves cases against dual nationals. Here, we file requests for prosecution in soldiers' own countries, and thus jurisdiction in these cases is uncontroversially based on the principle of nationality. We can therefore proceed more slowly. This time allows us to collect additional evidence and work with parties both within governments and civil society to further lay the necessary political and legal groundwork for successful prosecution. There is no statute of limitations for these crimes, and states' obligation to act never expires. For our part, we are committed to pursuing the perpetrators of this genocide for as long as they live. The third tier involves filing charges to and sharing information with international legal bodies like the ICC. For example, on May 3rd, on what should have been the celebration of Hind's 7th birthday, the HRF presented war crimes charges to the ICC against the commander of the armored brigade responsible for Hind's murder. The charges were the result of over a year of research, which remains ongoing to identify and build the cases against the rest of the soldiers responsible for this horrific crime. In all three tiers, we file cases in which there is actionable evidence for war crimes, crimes against humanity, or genocide. For each filing, we look to international instruments like the Geneva Conventions, the Romm Statute, and related treaties, as well as domestic legislation in the relevant jurisdictions. While there is little disagreement that Israeli soldiers have committed war crimes and crimes against humanity in Gaza, save from the perpetrators themselves or their most cynical or deluded international backers, there remain questions regarding domestic prosecution of the crime of genocide, largely due to the ongoing hearings at the International Court of Justice. In January 2024, the ICJ found that there was a, quote, real and imminent risk of irreparable prejudice to the plausible rights of the Palestinians of Gaza to be protected from acts of genocide. The court thus issued provisional orders in January, March, and May of that year requiring, among other things, that Israel prevent all of the constituent acts of the crime of genocide enumerated in the convention, and that Israel, quote, ensure with immediate effect that its military forces do not commit any of the above described acts. Israel continues to disregard these orders. Indeed, since Israel broke the ceasefire agreement in March of this year, it has renewed its genocidal assault with even greater vigor. We respect the ICJ's orders and its ongoing hearings, but we cannot wait for a final decision on the merits to act. For us, and certainly for the Palestinian people, it is all too clear. The genocide is not merely plausible. It is not an imminent risk. It is here and it is happening. It is important to note that it is not only direct killing that is proscribed by the convention. Within the context of this genocide, actions like the systematic destruction of almost all housing in Gaza must be understood as a part of the effort to subject the Palestinians in Gaza to conditions of life that are intended to cause their physical destruction in whole or in part. Likewise, the systematic destruction of Gaza's healthcare facilities, as well as the intentional infliction of starvation upon the people of Gaza, must be understood as a part of the effort to impose measures intended to prevent births. That is, while not every war crime or crime against humanity is also tantamount to the crime of genocide, many are, and each act must be evaluated in that context. States are under no obligation to wait for a final ruling on the merits in order to charge genocide under their own domestic laws. Indeed, let us recall the full name of the Genocide Convention, the Convention on the Prevention and Punishment of the Crime of Genocide, prevention. States have an affirmative duty under the Convention to take measures to prevent the perpetration of genocide, and among these measures is the duty to enact legislation into their domestic criminal codes which would provide for the punishment of the crime of genocide and to pursue prosecutions thereunder. Many states content themselves with merely naming this genocide for what it is, without taking any further action. But the act of naming alone should have been enough to spur these states to undertake prosecutions. Despite the above-mentioned legal obligations, there has yet to be a prosecution against either a traveling soldier or a dual national. States are largely failing to uphold their legal obligations, even to initiate investigations into perpetrators within their borders. At best, this is a dereliction of duty, and it can begin to look like willful ignorance, or worse. Should states' failure to prosecute known perpetrators within their jurisdiction become a pattern, they risk complicity with Israel's genocide. We have done the research, we have compiled the evidence, and we have assembled the prima facie cases, but we cannot, on our own, initiate prosecutions. We cannot file Interpol red notices. We cannot make arrests. Only states can take these actions. Which is to say, we are doing this work because states are not, because the international community is not. We say this, however, not just as a recrimination, but also as an invitation. So to the state observers in the room and who may be watching, let us work together to help you fulfill your international obligations. Let us maintain open lines of communication regarding the entry of traveling soldiers and the return of dual nationals. We are willing to share our files at any time. Let us assist your prosecutors with dossiers of evidence and filings on their legal ramifications. We have a vast and highly skilled research team. We have extensive files on individual perpetrators, as well as extensive thematic files on specific crimes like torture or the destruction of civilian property. We know the Israeli military structure. We know where and when its units were operating, from the division level to the brigade to the battalion and all the way down to squadron. Let us assist with discovery as cases proceed. Let us use our international network to bring lawyers from across the globe together to bolster information and strategy sharing among parties. Let us together work to foster solidarity within and among states to better withstand the inevitable political backlash from those who would like to see this genocide continue. To the civil society observers in the room, our recommendations are similar. We all have the same goal, ending impunity. And to that end, we would like to see as many organizations as possible undertake this work. But in order to pursue our shared goal efficiently, we must coordinate our activity to avoid duplicative or potentially contradictory actions. We must share information on both the evidentiary and strategic levels. The HRF's legal strategy is not only about holding the perpetrators of these heinous crimes to account, but also about restoring, or rather attempting to create, for the very first time, true rule of law on an international level. The genocide has been a test for the entire institution of international law, and so far it has been found wanting. It is precisely because of the impotence of international law, an impotence cultivated by a world system in which a few powerful states, namely the United States and Israel, are capable of positioning themselves above the law's reach, that the atrocities in Gaza can continue unabated. The post-war international order was designed to prevent and punish crimes like those that Israel, with the full backing of the United States, is committing in Gaza. And if it fails to meet the present moment, it will reveal itself merely as dead letter, a reversion to might makes right. Justice demands these prosecutions, and it is only through widespread and robust accountability that we can even begin to ponder a durable end to the ongoing colonization of Palestine and the denial of the Palestinian people of their right to self-determination. International law depends upon states for its implementation, and thus states bear the responsibility for its present failure, but also they have the ability to correct course. Indeed, if we are to have any confidence in international law as such, in the idea of rule of law as such, then the actions urged by the HRF are exactly the kinds of actions that states must undertake. Thank you.